why mediate? What I'd like to do is tell you what's good about mediation, the value of mediation. My name is Richard Lee. I'm 25 years a solicitor, and I am an accredited mediator. A good starting point is what brought me to believe in mediation as a means of resolving disputes. Many years ago, I was involved in a serious High Court case. Mary, that's not her real name, had to go to court because her house was badly damaged when a neighbour had works carried out. For Mary, getting into the witness box, giving evidence, was very stressful. At one point she felt she couldn't do it, but she was a brave woman. She got into the witness box and she gave her evidence. She told her story. At the end of the court case, the judge made a decision, and Mary won her case without difficulty. The sad part about this story is that a short while later, Mary died of an aneurysm. And part of me suspects that the stress of the court case did not help her condition. That led me to the question, is there another way? And the answer is yes, there are other ways. You don't have to go to court to resolve a dispute. ADR, Alternative Dispute Resolution, is available to everybody. And what I want to talk to you about today is one particular form of alternative dispute resolution, which is mediation. And the strongest way that I can talk is to say mediation is more likely to succeed than to fail in resolving a dispute. Or put another way, if you go to mediation, it's more likely that you're going to find a resolution than fail to find a resolution. So what is mediation? In plain language, mediation is a private, confidential process where the parties to a dispute are assisted by an experienced and skilled mediator to reach a resolution to benefit the parties. Importantly, you retain the right to go to court. So what's good about mediation? As I said, it's private and confidential. A skilled mediator will manage the process and will help to create the conditions necessary for the parties to talk to each other and to hopefully find a resolution. It's cost effective. It's not as expensive as going to court. It's quicker. There's no need for formal court procedures. It's flexible and not restricted by rules and limitations of court. I was involved in a medical negligence case a number of years ago, and the injured party, by and large, just wanted an apology for the wrong that was done. That was his main concern. And I feel that if mediation had been available to him, then mediation would have delivered the apology that he sought, which for legal reasons a court can't deliver. An apology is often seen as an admission of liability. But because mediation is a without prejudice process, people can apologise if there's a wrongdoing that needs to be apologised for in mediation. Mediation will become binding if there's an agreement reached, a resolution reached, and the parties sign up to that resolution. But unless there's an agreement reached, well then the process is without prejudice to your legal rights. The parties are in control of the outcome. The mediator is in control of the process, and it's important to bear in mind that the mediator is not a judge. Another important part of mediation is that it gives the parties an opportunity to talk openly. It provides a forum. The purpose of mediation, in a sense, is to be forward-looking. It enables people to avoid permanent damage and fallout. If you go to court, what can happen is there's a winner and there's a loser, and there's a permanent divide between the parties involved. How does it work? At any stage, parties to a dispute can request that the dispute is brought to mediation. And it can be brought to mediation by agreement. Mediation cannot be forced. If the other parties agree, then a mediator is appointed who will control the process, including setting out the procedure to give the mediation the best chance of success. How do you appoint a mediator? Usually, the names of 3 mediators are suggested to the other party for agreement. The Chartered Institute will be happy to give you the names of experienced and skilled mediators. Then hopefully the parties will be able to agree on who their mediator should be. If an agreement can't be reached, then the parties can agree that a body such as the Chartered Institute will nominate a mediator for them. It should be borne in mind that if there is a pre-existing contract between the parties, as can happen in a commercial dispute, that a mediation clause may set out how the mediator is to be appointed. Mediation is not for every dispute, but it will help in many situations. So typical examples would be commercial and contract disputes, workplace disputes, family disputes, property and boundary disputes, succession and probate disputes, consumer disputes, insurance disputes, negligence disputes, financial disputes, planning disputes. I'd like to finish now with what I'll describe as a happy story. Again, the name has been changed, but John had a difficulty arising out of his mother's will. In her will, John's mother left a gift, and there was a dispute within the family as to how that gift was to be used. As can often happen, it got heated, it got intense, and there was a danger of permanent division occurring within John's family. The good thing in that instance is that the brothers and sisters agreed to go to mediation, and with the assistance of a skilled mediator, a resolution was found which accommodated all of the family with no after effects.